The views and opinions expressed on this website and in these videos are solely those of the original authors and are not legal advice. These views and opinions do not necessarily represent those of CELA or any other contributors to this website. No attorney-client relationship is formed by viewing the video.
This video is on disability leave rights when disaster strikes, brought to you in partnership by the California Employment Lawyers Association, the California Governor's Office of Emergency Services Listos program, and the Disaster Legal Assistance Collaborative. Under the California Fair Employment and Housing Act, otherwise known as FEHA, employees with disabilities have the right to ask for an accommodation that enables them to perform the essential functions of their job. The employee does not need to request a specific type of accommodation or to identify the specific disability that needs accommodating, but simply must list the restrictions caused by the disability. An employer with 5 or more employees must first consider the employee's request for a specific accommodation and either grant the request or open a discussion, an interactive process, about what other types of accommodation may be equally effective. An employee who requests accommodation is protected from retaliation even if the employer determines that the employee is not entitled to the accommodation. Say, for example, you work for an employer with 5 or more employees, so your employer must comply with these laws. You have asthma. That's a disability because it's a chronic condition that makes it difficult for you to engage in the major life activity of breathing. Picture this. Wildfires are roaring around the region, covering your work site with smoke. Smoke from the wildfires makes your asthma symptoms much worse. You need to see your doctor about this. You call in sick and explain the situation. Your doctor recommends you take a few days off until your breathing goes back to normal. Your doctor writes a note for you to give to your boss. The note states you have a respiratory condition. You are having difficulty breathing due to the wildfire smoke, and you will be off work for 2 days. So your doctor's note is a request for a specific form of accommodation for your disabling asthma. Your employer doesn't want to grant you time off, so it opens up an interactive process by suggesting that maybe you could work at a different facility that has air conditioning. You explain that your doctor's note says you still need time off in order to recover from the problems that the smoke has already caused. Your employer grants your request for 2 days off. Please note that other laws may provide stronger protections for an employee's serious health conditions, such as the California Family Rights Act, or CFRA, which applies to employers with 5 or more employees. Employees may want to ask their employers to apply the CFRA for leave regarding their serious health condition before any other law. To ask other questions or find more resources online, visit the California Employment Lawyers Association or the Disaster Legal Assistance Collaborative.